Hi everyone, it's Amie Mish-Wills from Enterprise Legal, and I wanted to jump on here today to give you my top 3 tips for employment agreements. So my first tip is to actually have employment agreements in place in the first place. Now, I know that might sound trivial, but each and every day I am surprised by how many employers simply don't have employment agreements in place. And it might be because the age-old perception that they're not really necessary, but unfortunately in today's age and in our current employment law climate, contracts of employment are essential. They're a very essential tool to not only ensuring that the obligations between the employee and the employer are crystal clear, they're also vital for enforcing certain obligations and requirements that the courts say are simply not implied nowadays. So for example, the implied obligation of mutual trust and confidence is no longer accepted to be something that an employer can simply imply. It needs to be included as part of the contract. You've also got things like restraints of trade. They cannot be implied. They have to form part of a legally binding contract, and they also have to be drafted very carefully. It's because of these things and a lot more that it's important to have an employment agreement in place that crystallizes the duties and obligations between the employee and the employer, and it'll save you a lot of trouble down the road. My second tip is to ensure that your employment agreements actually reflect the industry, the business, and the role of your employees. Now, the reason why I say this is because a lot of the times I see a lot of very generic employment agreements that, to be honest, don't cut the mustard. You need employment agreements that are tailored to the risks and liabilities that arise out of your industry and your business, and also reflect the duties and responsibilities of an employee's particular role. That kind of contract will help you far more down the line than a generic contract will. And this is why it's important to make sure that they are tailor-made to you, your employees, and your industry. My third and final tip is to have them reviewed. Not only regularly, you should always be looking at your employment agreements. They shouldn't be like cement where you wet and forget. You should be picking them up and reviewing them constantly to make sure that they reflect what is essentially a rapid changing area of law. In employment law, you have awards changing, you have legislation changing at a very, very fast pace. And so it's important to make sure that your contracts are keeping up with them. It's also important to make sure that your contracts are keeping up with how your business has evolved, or how your employees have evolved. For example, changing to different roles. You don't want to try and enforce a contract against an employee who's maybe gone through the ranks over time and is leaving on a much senior position when their contract reflects maybe when they started with you and it's much more low level. So you should always be making sure that you're reviewing your contracts regularly. And the second part of this tip is that you should also get them reviewed by a professional, because we can provide you with the tips and the know-how based on what has been happening in the employment law sphere, and we can make sure that your contracts appropriately protect your business and your interests, and also reflect, like I said, the risks and the liabilities arising out of your industry, and we can also make sure that they're suitable to your employee's role. If you have any questions about employment agreements or you'd like any assistance, I encourage you to get in contact with Enterprise Legal's Workplace Relations team. We're here to help you every step of the way, and we also have a free workplace relations health check where we can check your employment agreement for you at no cost.